1, 2, 3. Oh, you got me that time. 1, 2, 3. You waited a second. Okay, 1, 2, 3. You did it afterwards. Okay, so
I think they get the point.
We're we did this before and I beat you a few times. So
I'm not good at rock, paper,
okay,
scissors.
you won this time. But so the reason that we're doing that is because we have a new decision from the Supreme Court of Canada. It's very exciting.
Hot off the press, judgment rendered June 13, 2025.
Yeah. It's called RV Kenmore, KINAMORE, 2025, SCC 19. But there's some issues we'll get into about whether or not they gave proper guidance to people who practice law and have to deal with these pretrial applications and stuff, which we'll discuss. There's some concern about whether or not they gave clear guidance or if it's just like playing rock, paper, scissors. Okay.
Yeah, and it's actually a very, very important decision that, frankly, the Supreme Court of Canada had dealt with in RV.
Yeah. That was 2019. There was a decision called RV.
Yeah, and then it kind of got ignored. And then they had the chance in JJ to do a comprehensive review of all the issues when they decided that the legislation was constitutional, and they didn't deal with an issue like this, and now we have an important decision.
So a few things packed up in that. First of all, RV had an issue potentially before the court, but they declined to make a ruling on it. They just made commentary saying when the Crown leads evidence in that case.
Let's tell them what this is about, because we've got them on the edge of their seats. What's the decision about?
So this decision in Kenmore.
You can't imagine anything more exciting than this. So
I know, it's very exciting.
Are you ready?
Actually.
Are you ready? Okay.
And in fact, it's not just exciting. It's like it's precedent setting in terms of how we're going forward.
Yeah,
in
it's
sexual
good.
assault trials.
It's good.
But so what we're dealing with is whether or not when Crown leads evidence of sexual inactivity and in specific virginity, are they allowed to do that without having a pretrial motion, which for the Crown would be a voir dire, a trial within a trial, as opposed to a formal application, much more onerous on the defense. But the Crown has been basically open to leading whatever evidence they want because it's presumably in favor of the complainant.
Yeah, so let's break that down for a second. So it's not just sexual inactivity, but it's relevant in this case. So any Crown-led evidence of other sexual activity or messages in their possession of sexual activity or sexual inactivity nature, or of a sexual nature now has to be subject to an application by the Crown. Whereas before, the Supreme Court of Canada kind of said, yes, it does, but then it kind of went by the wayside.
It had no teeth. Yeah. And in fact, there was a decision.
I thought it was kind of important what they said, but nobody really paid attention to it.
I was excited about it with the RV decision, but then another case, Langan, came along, which I won't get into because it makes me emotional.
Makes you upset.
But they had the opportunity to reinforce RV, but they didn't. And so one of the things that happens, unfortunately, is that the Supreme Court will say, this isn't the case to make that decision. And they had the opportunity, but they said it's not the right case. And so that means that a number of other appeals go forward without the benefit of that decision until they find the right case.
That's right. And
this is finally the right case to make a very important decision.
Let's give the facts. So the accused and the complainant met in May of 2020 and exchanged information for their social media accounts, which were used as their primary means of communication, which is not surprising these days. Months followed, and on August 3rd, the accused and the complainant met at the accused apartment. The events that day led to the accused being charged with sexually assaulting the complainant. At trial, without a voir dire, the Crown introduced screenshots of social media messages that were exchanged between the accused and the complainant in May and June 2020. Some of the messages were explicitly sexual in nature. The messages included many conversations in which the complainant indicated disinterest in a sexual relationship with the accused. Some of these discussions referred to the complainant's virginity, and evidence of the complainant's virginity was also introduced through the testimony of the complainant and the accused. I will say there was also other messages that was introduced and the defense cross-examined on that had other sexual information, which would suggest that the complainant was interested in sexual activity.
Right. Saying, bring it on kind of thing.
Bring it on, let's try it, something like that. So it cut both ways. But both the Crown and the defense relied on this evidence. Okay, that just is a short sort of summary of where we are with the evidence. So you've got messages about sexual inactivity or desire not to have sex, some messages with respect to sexual activity, and you've got messages about her virginity. And of course, there's discussion about that as well in the evidence of the complainant. No voir dire, no vetting before the judge, nothing, zero.
Mostly because it's been determined prior to this decision that the Crown will never lead evidence to prejudice the complainant or to undermine the integrity of her dignity. And so the Crown's typically aligned with the complainant. So they said it won't violate, just prima facie, won't violate the rules against
the twin myths.
Privacy interests in the twin myths. But it opens up.
Which actually is a bunch of bunk.
It is.
Because evidence has to be relevant to a triable issue, and it can't be prejudicial, and its probative value has to outweigh its prejudicial value. This is just a common law principle. Let's just be clear. You can exclude, a judge has discretion to exclude any fucking evidence at common law, which is prejudicial and not outweighed by its
and
probative
from
value.
The real issues.
Leaving that aside, that's the common law. That's the common law. A judge has that discretion no matter what.
So we've talked about this on a number of podcasts. We've done a bunch by now. We're getting close to 100, right?
We're way over 100.
We're way over 100.
We're getting close to 200.
So we've talked about this before, and I've been saying this for a long time.
You've been enjoying this so much, you haven't really been counting.
That's true. That's true. But I've been arguing this for a long time, that arguing that a virgin is less likely to consent and more worthy of belief is the exact same thing as saying a person who's not a virgin is less worthy of belief and more likely to have consented. And that's what this decision actually determines for the first time.
So let's frame that. Sexual inactivity evidence, encompassing evidence that the complainant has not previously engaged in or prefers not to engage in any sexual activity, certain types of sexual activity, or sexual activity under particular circumstances, forms part of a complainant's sexual history and is thus presumptively inadmissible. That would include, I'm a virgin. I'm a virgin. Okay, so furthermore, to facilitate consistency and predictability in the management of sexual offense trials, the common law procedure governing Crown-led sexual history evidence should mirror the statutory scheme of 276 that applies to the accused. So, in the instant case, the social media communications that included discussions of the complainant's sexual activity and inactivity were presumptively inadmissible sexual history evidence. The trial judge erred in failing to hold a voir dire to determine their admissibility. Since the trial judge's assessment of credibility of the accused and the complainant was inextricably intertwined with this evidence, they had to send it back. They had to overturn the conviction and send it back. Let's talk very specifically now about what you said, because we now know generally the ruling that evidence about sexual inactivity is presumptively inadmissible. Let's talk about the concept of saying, I'm a virgin, and what does that mean? What you're talking about are inverse myths, right? So let's talk about inverse myths.
And they specifically address that at paragraphs 71 to 73 in this decision.
But let's flesh it out right now so everybody gets it, because this is important. We've argued this in court when we faced this successfully. But now we've had the Supreme Court of Canada finally clearly state this. And I know you like this, so the table is yours.
In the past, evidence of virginity was permitted as Crown-led evidence because it was a physical state. So they said it wasn't to do with myths or stereotypes about experience or inexperience, but it had some relevance to the physical experience that the person had in the act of intercourse, and that could lend some sort of probative value to the trial. That's how they kind of got through this. But invariably, that evidence, that little pathway was used as a method to use the evidence of virginity in order to argue that she was less likely to consent. And this is particularly difficult when somebody was intoxicated and then wants to say, I don't have memory of it, but I know I wouldn't have because I'm a virgin.
I'm a virgin. I would not have done this.
So now there are opportunities for the Crown to get that evidence in, but they have to be very, very clear about what inferences they want to be drawn from the evidence of virginity. Or, when we talk about sexual inactivity, we're referring to messages, for example, of somebody saying, okay, I'll come see you, but I'm not going to have sex with you. So they're advanced messages of non-consent. They're advanced messages saying, I have no intention of having sex with you. And that is supposed to bolster their claim that they didn't have sex because they said in advance they didn't want to, which leaves aside the fact they can change their mind.
Right, but we don't have a problem with the Crown using it. Just like if there's messages of advanced consent, and the Reimer decision, we've been on, and I guess PS or whatever else, the case we went through, we don't have a problem with it as long as you properly have a motion and ground it in the evidence.
And they mention Reimer in this decision as well, that just as the defense can lead evidence of prior discussions about sexual activity that they intend to engage in,
right,
and that's part of a legitimate narrative that can, gives proper context, not just generic context, but it actually does have some relevance to whether or not the person then engaged in the specific acts that were spoken about, that the Crown could still...
There is an inherent logic to when two people are talking about having sex on a particular day...
In a particular way. That those messages are relevant to whether there was consent that day. Right.
You have to have consent on that day and throughout the act in question, but there is inherent logic to it. Similarly, we agree, and the Supreme Court of Canada says this as well, that if there's messages about, I'm not going to have sex with you, but we can get together and watch a movie, I'm not going to have sex with you, but we can get together and read a book, that'd be admissible as well, as long as the motion is brought, it's properly relevant to an issue at trial, and it's grounded in the evidence. Nothing wrong with that.
And as we've mentioned before, and it's worth repeating too, that somebody's intention to have sex doesn't mean that they're now committed to it and they can't change their mind. Somebody's intention to not have sex also doesn't mean that they didn't change their mind.
100%.
So the Crown can still get that evidence in as long as they're very clear about the limitations on it. They can't argue that somebody's unwillingness to have sex or expressions of that, or the fact that they're a virgin, means that they could not or would not have consented.
Great. So let's just make this very clear, because this is great what the Supreme Court of Canada has said. Sexual inactivity evidence may invoke inverse twin myth reasoning, inviting the trier of fact to conclude that because of the complainant has been sexually inactive, 1, they have a propensity to not consent and therefore were less likely to have consented to the sexual activity that forms the subject matter of the charge, and 2, they are more worthy of belief.
Right.
The reasoning is legally impermissible because it remains grounded in false assumptions about complainants. These myths and stereotypes about complainants undermine the fairness of a trial by distorting its truth-seeking function. Screening of sexual inactivity evidence also facilitates the protection of the complainant's dignity and privacy. Fine. While sexual inactivity evidence is presumptively inadmissible, it is not categorically excluded. It is only inferences rooted in inverse twin myth reasons or analogous forms of discriminatory reasoning that are prohibited. Let's say this again. This is what you spoke about. It is only inferences rooted in twin myth inverse reasoning or other forms of discriminatory reasoning that are prohibited. So again, because somebody's a virgin, just like Diana says, that means they would not or could not consent. That is impermissible reasoning.
Or that they're more worthy of belief because they're chaste.
That's right.
And, if, and the reason to repeat again, if you were to believe that, that would mean that an unchaste woman is less worthy of belief. And you can't make either argument. If you make one, you're actually arguing for the opposite at the same time.
It's very good. Now, the Supreme Court of Canada has made it clear as well with this. It is incumbent on the party seeking to introduce the sexual inactivity evidence, let's say the Crown, to identify with precision how the evidence is relevant to a live issue at trial through the use of permissible inferences. Finally, we have a very clear statement about this.
Okay. Now we're going to get into the lack of clarity.
Let's just lay out some things we think the Supreme Court of Canada, they have said, and I think it's pretty clear, but I agree with you that when it comes down to practical application, we've got some problems
Well,
here.
and that's what we need to worry about, because they always talk about giving guidance to the lower courts and giving guidance to lawyers about how they're supposed to go about.
Yeah, I mean, the reality is this.
Pretrial
We'll get
applications.
into this later, but the Supreme Court of Canada gives its ruling.
It makes me angry, Joseph.
I know, but then it's up to the rest of us who actually do the heavy lifting in the industry to work it out. So you've got judges in the Superior Court, judges in the Ontario Court of Justice here in Ontario, who will then lay out procedures, because that's the only way we can survive in the trial process. But
I do understand that it's very difficult to lay out a procedure that everybody interprets in the same way, because that's one of the things with court rulings, is that people interpret it in different ways, right? So the lower courts may disagree about how to interpret that decision. They did, I think, make a very good attempt to be clear. They set out, in this case, for Crown-led evidence, they set out a two-stage procedure that is intended to mirror what the defense has to do.
right, so the two-stage procedure, which is already set out for what the accused has to do in the criminal code, should give the basic structure that would govern the common law process for admitting Crown-led sexual history evidence. The Crown must prepare a written application that sets out detailed particulars of the evidence that it seeks to adduce and the relevance of that evidence to an issue at trial, providing fair notice to the accused and the court. The Crown should generally bring its application before the trial commences. One would f***ing hope so.
Generally.
Yeah. But mid-trial
I'm gonna pick on
applications
that
may
word
be
soon.
necessary where there is a material change in circumstances. At stage one, the judge must assess whether the Crown has complied with its procedural obligations and whether the evidence sought to be adduced is capable of being admissible, very similar to what we have to do. Evidence will be incapable of being admissible where the stated relevance of the evidence engages prohibited reasoning. At stage two, similar to the process we have when we're bringing for a defendant, the judge must decide whether the Crown has proven on a balance of probabilities that the evidence is relevant to an issue at trial and its probative value is not outweighed by its prejudicial effect. In weighing the probative value and prejudicial effect, the Crown-led sexual history evidence, trial judges must consider the non-exhaustive list of factors set out in Section 276, which we go through all the time in a 276 motion.
So this is them giving parity to the same rules that apply to defense apply to Crown-led evidence, and they're telling judges they have to assess it exactly the same way.
And interestingly, the complainant does not have the automatic standing to make submissions on stage two,
Right.
unlike our procedure.
But they may be given standing.
The judge has the discretion.
This is the thing that I have concern with, and I understand why the Supreme Court wants to leave it open to extenuating circumstances. There may be a trial that has reason because of how things arise as evidence comes out, that it may require some sort of openness. Not like, if you don't bring the motion in advance of trial, you don't get one. That's not fair, because things can come up at trial. So they're trying to leave it open a little bit. But there is some ambiguity to me in this generally thing. One of the more important things is that they specifically note in this decision that what the Crown intends to lead in terms of sexual history, evidence or other evidence of a sexual nature may influence what the defense wants to do in terms of their pretrial application. And so they indicate that it's ideal for both applications to be brought at the same time. Mm-hmm. That's why we played rock, paper, scissors.
Who brings it first?
Who brings it first?
This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you.
Right. So practically speaking, there's one other aspect I want to read, which is interesting because it's an issue you raised before. But let's just talk about that for a second. Okay. From a practical standpoint, for those of you who are like us lawyers and are doing this work, we have to think way ahead of time, no matter what. And we have been putting into our applications Crown-led evidence. Okay, we lay out in our applications anticipated Crown-led sexual history evidence. And we've been doing this now for 2 years.
And we name and anticipate that anything of a sexual nature that's mentioned in disclosure, be it the complainant statement or otherwise, messages provided, and we assume the Crown's going to lead them because we're not told otherwise.
No, and we try and go through it, but often you don't get down to the nub of it. And it's been murky up till now. It's been murky because nobody paid attention to RV. Nobody paid attention to...
because of Langan.
Because of Langan, and because of that, it's become very murky. So we would deal with it anyways.
Yeah.
And so it would be in our 276, 278 application, just so that we have coherence. There was no way to bring a proper, coherent application without dealing with maybe the evidence. You have to put in your application...
We have to assume they're going to lead it.
You have to put in your application what's the evidence on behalf of the Crown. So you do a summary. And you do references to the evidence. So in that as well, we have to identify potential Crown-led evidence of sexual history that we may or may not be objecting to or maybe using for our own purposes.
Sometimes we agree with that.
Absolutely.
Yeah.
We've already been doing this 2 years, 3 years now. So it's 2025. We've been doing this for over 3 years, that portion in our applications.
Yeah, since the JJ ruling and all this other stuff. And, yeah.
So frankly, you have no choice. Let's just put it that way.
And
there's no choice.
And we found it beneficial. We previously said, like, take lemons and make lemonade, But the way we've done it, and I don't know if everybody does it, I don't think they all do it this way, but it's actually an opportunity for the Crown to be informed, because we file our applications very early. Probably much earlier, much earlier than 7 days.
Usually 3 to 4 months ahead of time.
90, yeah. But it's an opportunity to bring to the Crown's attention things that they may need to address in terms of what they intend to lead.
Forcing them to think about
it. And forces them to think about it, and also make sure that nothing is left aside. And, we've talked about this, it's gotten outrageous in terms of what something of a sexual nature is. Even just saying the word flirting is apparently one of the no words anymore. And so what is the Crown going to do when the complainant wants to say, oh, he was flirting with me earlier? The Crown's going to have to address that now too.
I agree. I mean, we've talked about how we have certain motions that go over things that are just absolutely patently absurd. But leaving that aside, the practical point is, in this case, what you're trying to say is one of the areas of ambiguity is the Crown should be bringing this with fair notice to the accused at least 7 days before trial. Okay, well, that's stupid. Let's say you have a 3-day trial booked for a sex assault. You bring the application 7 days before. Defense has to respond. Maybe they want to bring application. When the hell do you argue this? Day 1, day 2 of your actual trial? Then you're not going to get your trial done. You're going to need an adjournment and pick new dates. So it makes no sense whatsoever. This idea of 7 days before or whatever outrageous. The judge deems appropriate for the Crown is absolutely absurd. It's just going to hijack the trial.
Not only did they say 7 days, they said it must be 7 days in order to give the defense time to decide if they want to bring their own application.
They're assuming the defense hasn't thought about it, which we are saying to everybody who is involved in this work. We all know, and you know already, you got to do it ahead of time, and we're going to bring it anyways. We cannot rely on the Crown.
But look at the way they did this. Defense has to bring an application at least 7 days prior. But then they say the Crown has to bring an application 7 days prior so that we can decide how we're going to respond to it. And if we want to bring our own, which then makes it less than 7 days.
This is just asinine. It's just, the good thing is they've made a decision about something that's important. And then we go back to what the practicality is and how we have to do this.
I'm just staring off into space for a moment, pretending this all makes sense.
But this is not the first time we've seen this. There's many decisions that come down from higher courts where you basically have to work out the procedure, right? Because they don't think about it.
The practical application.
Yeah.
Yeah. No, it looks good on paper, but in practicality, in actual practice.
The value here is finally in the substantive decision that the other sexual history evidence, including history of inactivity or virginity, is now presumptively inadmissible, and the Crown should be bringing an application.
Has to.
In writing, although a judge has a discretion in their managerial role to do away with it in writing and just have it orally. But we're going to know, I'm telling you, it's going to be 90% of the time it has to be in writing.
Thing is, it all looks laid out really clearly, has to be in writing, but then, a number of paragraphs later, they say, or a judge can say it doesn't have to be. It could
Let's
just be an
look
oral.
at that in a moment, but there's just one thing I wanted to say here. So we talked
It
a little...
either is or it isn't in writing.
We talked a little bit about transparency of decisions, and that's important because you need to give guidance to other courts
So it's
on these
applied
applications.
the same way in every province.
Not even that, just from case to case. So just listen for a second. The contents of the Crown's application, the evidence taken, the information given, and the representations made in Stage 1 and at Stage 2 hearings must not be published, transmitted, or broadcast in any way, because they're in camera. The decision of the
In
judge...
camera means that the public can't attend because it's
without the public. The decision of the judge in Stage 1 may be published after consideration of the complainant's right to privacy and interests of justice. The judge's determination and reasons following Stage 2 hearing should not be published unless some of the evidence is held to be admissible or in circumstances where the judge determines that the reasons should be public after considering the complainant's privacy rights and the interests of justice. We spoke about this before because in other decisions they sought to seal the actual reasons. And here's the problem. It really is in the interest of justice that the decisions on Stage 2, Stage 1, yes, but particularly on Stage 2, are actually reported so that we have a history of precedent where we don't have to recreate the wheel every single fucking time.
And it creates consistency.
It creates consistency. It makes it easier for us to make the arguments. We have coherent law.
Right.
Right? We have coherent decisions. So I see this as a bit of a... yes, I understand the caution, but I would have liked them to say that there truly is a value in published decisions, taking into consideration the fact that this should occur not only when evidence is admitted, but when it is in the public interest, because it is considerably in the public interest that we have consistency in our courts.
There's a specific aspect of this application, this decision, that I want to focus on right now, and maybe you can tell me what your take is on this. So the Crown is supposed to bring this application supported by an affidavit, but the complainant is not a compellable witness. And I found it rather stunning that at paragraph 55, they said that because the complainant is not compellable, but an affidavit is required, and you can explain what that means, that someone familiar with the complainant's sexual history could offer testimony, so that
Police officer.
she's not compellable.
Yeah, one of the police officers could be the affiant.
Yeah, it could be through an affidavit or viva voce testimony. So when you file a motion, the motion has to be supported by an affidavit of either, in the defense case, it's usually supported by an affidavit by the accused, but you could also offer an affidavit from somebody who's familiar with and can affirm that
could be a clerk or a paralegal on the file who's put together and reviewed all the messages and has reviewed, the statements, and you can have an affidavit in that instance. But it's also said in our legislation, for example, on Stage 1, you don't need an affidavit. And on Stage 2, you do, but you don't need to lay out everything of your defense. So I don't have such an issue with who the affidavit comes from, because we all have the complainant's statement.
Right.
Right?
There's already a statement made.
So there's no mystery here as to what the complainant's going to say. They just want to insulate them from cross-examination.
Sorry, I'm just kind of laughing because we've had some disputes about that in pretrial motions where the complainant's lawyer comes in and goes, well, we don't think that's what she actually said, and they start debating what was said and what it means.
Yeah, so what you're talking about is when we're on motions in Stage 2 and the complainant's counsel is saying, we take a piece of the statement of the complainant and say, well, she said she likes to have sex at dawn because it's wonderful to look out at the window and see the sun rising at the same time that I have sex. And then the complainant's lawyer says, no, that's not what she meant. She meant she likes to have sex when there is a dawn, but not necessarily all the time, and usually when she's watching a movie. I don't know, some stupidity that they say, right? Because sometimes you can't even follow what they're saying.
They offer various interpretations.
But they offer interpretations of it.
She didn't actually say that she was having sex. She just said she likes to think about sex.
Actually, she was talking about her friend.
She was talking about her friend. Yeah. So,
If this sounds nonsensical, it's because we've actually had nonsensical submissions.
Submissions from the complainant's lawyer when they're given standing. So, and that's another.
But let's talk about this for a second. Let's just close the loop on this one, okay?
Right.
So there was a really great French lawyer who I was at a long public inquiry with, and he's now a judge. And when he'd cross-examine, say, okay, let's close the loop on this, with a heavy Quebec accent. Let's close the loop on this. So I like the expression, just to close the loop on it. Affidavit will have to be from somebody. We have the advantage of having this statement. We have a fairly good understanding of what they will testify to or variations thereof. So it's not so bad, but at least there will be an affidavit, right? Laying out the messages, laying out the relevance. At least there will be something.
Well, there's a clear clown position. crown position.
That's right.
There's a clear crown position. So that we understand what they're going to argue.
No negative connotation to that.
No. It was just
it was just a slip.
Freudian slip. So it at least gives us some outline and on the record, understanding of what the Crown's going to lead and what they're not intending to lead.
Absolutely.
That doesn't mean the complainant's not going to blurt things out in court.
100%.
That the Crown doesn't intend to lead. But it helps to put something on the record in terms of the intentions of both sides. And it helps to the judge to make easier decisions at trial based on what was discussed prior to trial. Absolutely. In terms of what's going to be struck and if there's a jury, what jury instructions to be given. And if it's judge alone, it's a little bit easier. I'll disabuse myself of that information.
100%.
Right? So one of the other things I thought was interesting about this, I know we're running a bit longer than we intended, but...
No, this is an important decision. I think for those who are like us lawyers who happen to watch this once in a while, this is a really good decision for us to talk about so that we're all informed and we can hold all parties to have, meaningful discussions before trial. Because what I wanted to say to you is, where we have these ambiguities, the reality is we have judicial pretrials. So whether in the Superior Court or we're in the Ontario Court of Justice, or you're in the same sets of courts across the country, we have to have judicial pretrials. And what has to happen now is we have to say, and we do try and say this, is, look, you have Crown-led evidence that you're going to call. Tell me what it is. What of these messages do you want to use? And you got to bring an application. And you're not bringing it 7 days before because I'm bringing an application too. So I'm going to file it. So can you please do your filing? I'll file mine 90 days before. You file yours 30 days before.
Yeah, and we often do a reply to the reply.
We always do now, yeah.
And but this is, I think, an extra step. And it's really interesting because some of the media have said that this case is going to help streamline things. It doesn't. It actually makes it's always become more complicated every time there's new legislation.
I absolutely have to go back to that case that we reviewed in one of our podcasts from the judge in Saskatchewan who did that academic paper at the end, which was a reflection of where we are, because the intricate layers, this is helpful to us because we are now mired down in all these motions.
Yeah,
but this is just...
It's as complicated as murder cases, if not more.
I've done murder cases that are less complicated.
Yeah, this is becoming more fraught with danger in terms of what you're allowed to say or not allowed to say and all the pretrial motions and everything.
Because there are so many ways that we're arguing about something that doesn't make sense. So, in any event, let me just say one other thing. I just want to be clear about this, because this is the value. Sexual inactivity evidence engages Section 276 and the common law exclusionary rule. Let's emphasize that, put a pin on it, and that is the law now in Canada.
And it applies to both the defense and the Crown now.
Absolutely.
Whereas before, the Crown just kind of went, I'm not arguing myths. So this is the thing that I wanted to...
We argued that evidence of sexual inactivity, because we argued at times, say...
We always bring it up out of an abundance of caution.
We bring it up out of an abundance of caution. We can say, look, it may be that the actual saying that we weren't active sexually in and of itself doesn't talk about sexual activity, but it does talk about their sexual history.
Well,
and it does.
In the defense narrative, it sometimes comes up because we often have clients who are in trouble because they withheld sex. And so,
Well, there's tension in the relationship because there's been...
So we want to bring up as part of our defense narrative that the animosity and motive to fabricate was a result of somebody being denied sex and feeling, and then maybe accusing somebody of cheating on them. Like, that can be a part of a very important and truthful narrative. And we always include that in our applications, even though it's actually an absence of sex, but we know it's of a sexual nature, and we always put it in. And
it's clear now this engages 276.
So there's one other thing that was kind of lightly touched on this decision, in this decision, and I don't think it was touched on enough, and I just want to hear your thoughts on this. They kind of mention, aside from the twin myths that say, like we talked about, a virgin is more likely to be trustworthy, more worthy of belief, and less likely to have consented. They also mention other myths and stereotypes, such as, some of these are like the doctrine of recent complaint. So it's a myth to say somebody's less worthy of belief because they took a year, maybe a decade, to make a complaint.
4 decades.
So can the Crown try to introduce evidence that they're more worthy of belief because they reported right away?
No.
If they intend to do that, does that require a pretrial application? Or do we just deal with that in submissions?
No, we deal with that in submissions. That is just a circumstance of the disclosure. So although a delay in reporting is not relevant to the credibility or reliability, let's say to the credibility of the complainant, the circumstances surrounding the disclosure is relevant, and it may be relevant to motive to fabricate. And it may be relevant to reliability through a whole host of other issues, particularly if it's significantly delayed. So it's just something we've had to deal with before. The Crown now could make the argument, even before they could make the argument, that because they've reported the same day, it's credible. Right? I mean, we faced that a ton of times.
Oh, yeah.
They went for a sexual assault kit right away, and then they went to the police and they gave a statement. We faced that all the time.
Well, they use the words parity and stuff like that in this decision, and that's one of the things I find so interesting.
I think they're saying they just want to align the regime that the defense has to follow should be the same in general that the Crown has to follow. So we have parity in the regime.
Yeah.
And that, I think that makes good sense, because imagine if you have a totally different scheme for Crown-led evidence. I mean, everybody will just pull their fucking hair out. It's too difficult.
I really wish I've been attacking this, like, I'm not happy about the decision, but I'm extremely happy about the decision. I'm just unhappy it took so long.
Yeah.
But at least it's here finally.
Yeah, I mean, we've had to argue about this there's a case right now we're setting down for trial. I just did the pretrial, and the Crown was good. This was prior to this coming out. And the question surrounds allegedly, the complainant being a virgin. Mm-hmm. I mean, that's such a laden thing in and of itself. I have to really say, like, pardon me, I know I'm going to get on for this, but, I'm a virgin. Well, how do we really know?
Well, and so this is the thing is that, and they
we have a
that
doctor's examination
in the
as part of this.
But the Crown wants to leave that evidence. It opens it up for the defense to make full answer in defense by saying, actually, do you remember Mark?
Look, I mean, when you have sexual assault kits, there's sometimes there will be certain evidence that can try and establish that somebody might have been less experienced sexually from vaginal intercourse, but just the concept of having somebody come forward without a sexual assault kit and say, I'm a virgin, therefore I would not have consented, is so laden with faults that I just think it's such a difficulty. But
it opens it up for us to say, hey, we actually know somebody you had sex with, you're a liar.
Yeah.
And then, now the Crown's invited that in because it allows for full answer in defense.
And so I brought it back to this pretrial I had. The Crown says, look, I have to flag this for you because the complainant says that she's a virgin. I don't have evidence of that. Crown said to me in a pretrial, I'm not going to give it away. And and the Crown said, I have to canvass it, but I'm not comfortable with it.
Yeah.
Even prior to this decision coming down. Yeah. Now, if they do want to run it, they have to bring a C-Boyer application.
And even like a good 5 years ago.
But I appreciated the fact that this Crown, like a few others I've dealt with, have said, this is fraught with issues.
Yeah. And like when we went to a Kingston trial, and I remember that happened as well. That we confronted the Crown. If you're going to allow her to testify in that way, then it opens it up for us to address those issues. And they made the decision that they weren't going to leave that evidence because it would open it up for full answer and defense. And that's, I think this decision really brings us back to that parity. And, I like that they use the word parity. They're attempting to balance the scales, and it's about time.
Yeah, this was necessary. So this is good. So, we commend this to anybody who's interested. The citation will come up on the podcast. It's a well-written decision. It's good. It's actually easy to understand, which is nice from Supreme Court of Canada. And it's finally we have definitive substantive decisions that's going to be helpful to us. So this is good.
That's a follow-up on RV, and I'm happy they finally recognized and found the right decision to make that, to follow up on what they said.
I'd prefer, though, when they had the opportunity to deal with the entire scheme, that they would have talked about this as well, because at that time we also had considerations as to what the Crown has to do in order to lead messages and other evidence. And so we could have dealt with it, but whatever it is, it's done. We have the substantive decision. I'm still squeaking. I think the chair's still squeaking.
That's all right. I got one more thing to say. 1, 2, 3.
We're tied.
All right.
Thank you. I hope you found this
Don't
interesting.
forget to like, comment, subscribe, share.
Hit notification.
Yeah.
And send us messages like you do, and if there's topics you want to hear from,
we read the comments.
It's really good. We did a really
suggestions.
long one last time on right to silence and stuff, and that was because somebody wanted to hear it. So please send it to us. Thank you very much. Have a good night.